Chapter 3. Administrative Law. Between the rule of law and what is called administrative law, happily there is no English name for it, there is the sharpest possible contrast. One is substantially the opposite of the other. In order to exhibit the true nature of this contrast between the rule of law and administrative law, each of which in its turn will hereafter be contrasted with administrative lawlessness, it may be convenient first to consider administrative law in outline and afterwards more particularly to examine some of its features. In France and in most other European continental countries, a system of administrative law exists. It is known in France as droit administratif. It is a system which is fundamentally opposed to the English conception of the rule of law, especially as regards exemption from the jurisdiction of the ordinary legal tribunals in the case of public officials acting in performance or purported performance of their official duties. In countries where this system of administrative law prevails, the rights and obligations of all servants of the state, and also of all private individuals in relation to servants of the state acting in their official capacity, as well as the procedure for enforcing those rights and obligations, are governed by special rules which are, in general, administered by special tribunals, and the principles underlying these rules differ essentially from the principles forming the basis of the law which governs the relations of private individuals towards one another. Under this system, the ordinary courts of justice are regarded as having no jurisdiction to deal with any dispute affecting the government or its servants, all such disputes being within the exclusive cognizance of the administrative courts, the chief of which in France is the Conseil d'État. This council was originally a purely administrative body, and though its composition has varied at different periods of French history, and it has gradually become more judicial in character, the members have always held office at the pleasure of the government of the day. Where, in the course of a case in an ordinary judicial court, it appears that a question of administrative law is involved, the court is bound to refer the matter to the Council of State for decision. Where it is doubtful whether a question of administrative law is or is not involved, a conflict of jurisdiction arises. Until 1872, it was for the Council of State itself to determine all such questions of jurisdiction, the Council thus having, in effect, the power to fix the limits of its own jurisdiction. By a law of 1872, a conflict court was established to decide questions of conflict of jurisdiction as between the administrative and the judicial courts. This conflict court consists of 9 members. 3 members are elected by the judges of the Court of Cassation, which is the highest judicial court in France, from among themselves. 3 members are elected by the Council of State, also from among themselves. 2 members are elected by the above-named 6 members of the conflict court, one of whom is usually a judge of the Court of Cassation, and the other a member of the Council of State. The Minister of Justice, a member of the government, is ex officio president. The 8 elected members hold office for 3 years, but may be, and usually are, re-elected. The Minister of Justice does not often attend the sittings of the court, though he may do so when the court is equally divided. A vice-president, chosen by the court from among its own members, usually presides. In France, a public official is not answerable in any court, even an administrative court, for what is regarded as an act of state, however unjustifiable his conduct may have been according to the ordinary law of the land. And agents of the government are exempted from punishment for any act of interference with the liberty or rights of citizens, if the act was done in obedience to the orders of a superior. On the other hand, damages may be recovered from the state itself through the Council of State for unlawful acts of agents of the government. Administrative law, therefore properly so called, whatever else may be said or thought about it, is at any rate a form of branch of law. The essential idea which underlies and gives meaning to droit administratif is not that state officials, in their official dealings with private citizens, are above the law or are a law unto themselves. It is rather that the position and liabilities of state officials, and the rights and liabilities of private individuals in their dealings with officials as such, form a separate and distinct chapter of law, which depends upon principles different, indeed, from the principles of the ordinary law, but nevertheless legal principles. Nor is it that the rights and liabilities of private individuals in their dealings with officials as such are matters which are beyond or beneath the reach of established legal procedure. It is rather that for these matters a special procedure is provided, which has its own courts, its own cases, its own precedents, and its own methods. An examination of the history of the topic during the last century and a quarter shows indeed some remarkable developments in the direction, not at all of extending, but always of limiting and curtailing the peculiar authority of droit administratif, and of rendering that which was once administrative more and more judicial in character. Yet the fact remains that at no time was the judicial element absent. The special courts were associated, in ways in which the ordinary courts were not, with the administration, but they were nevertheless courts which heard and determined the matters in issue. If one starts with the assumption that the government and every one of its servants enjoys as such a special class of rights and privileges against private individuals, and that the nature and extent of those rights and privileges are to be determined upon principles which differ from the principles of the ordinary law, it follows naturally enough that suitable steps should be taken in order to prevent either the government or the ordinary courts from trespassing upon the other's territory. It is in that sense that the expression separation of powers is used in countries where droit administratif is familiar. It means, of course, that while the judges in the ordinary courts ought to be independent of the executive, the government and its officials ought to be free from the jurisdiction of the ordinary courts. But the phrase, like so many other phrases, is often misused. In a country like our own, where the notion of droit administratif serves only by way of comparison and contrast, for the reason that the thing itself is completely opposed to the first principles of our constitution, the separation of powers refers, and can refer only, to the principle that the judges are independent of the executive. Yet the phrase is sometimes employed by the apologists of administrative lawlessness for the purpose of suggesting, by means of a confusion of ideas, that here also the government and its officials, while they are amenable to the jurisdiction of no other courts, are, or ought to be, free from the jurisdiction of the ordinary courts. In France, therefore, it is not surprising to find administrative courts, having their defined subject matter, existing side by side with ordinary or common law courts, having their defined subject matter also. Nor is it surprising that, for the purpose of ousting the jurisdiction of the ordinary courts, recourse has been had from time to time to the expedient of raising a conflict, élever un conflit, that is, of taking the point that the question in issue could not be determined by the ordinary court without encroachment upon the province of the administrative court. In other words, rightly understood, droit administratif is a definite system of law, the rules and principles of which, it is true, differ essentially from the rules and principles of the ordinary law governing the relations of private citizens inter se. Nevertheless, it is a system of true administrative law, administered by a tribunal which applies judicial methods of procedure. The Council of State, when it is exercising judicial, as distinguished from administrative functions, acts by a committee which is in many respects analogous to the judicial committee of the Privy Council, in the exercise of its jurisdiction to hear appeals from the dominions and in prize causes. The tribunal considers the arguments of advocates and delivers reasoned judgments. Those judgments are reported and form precedents from which a fixed system of legal rules has been evolved. In short, the system may aptly be described as a special branch of the law for the determination of questions of a particular kind, and the tribunal as a quasi-judicial tribunal for administering that special branch of law. End of chapter 3.